2. Program property ownership and land use controls and regulations. A section of land legally described as the north one half of the northwest quarter of the southeast quarter of a section of land, contains 40 acres. 20 acres correct. 10 acres. 80 acres. What is 20 acres? Question rationale. The section contains 640 acres. Divide 640 by 2, divide that by 4 and divide that by 4 to obtain the total area of land. How many square feet are there in an acre? 43,560 correct. 46,350 incorrect. 45,630. 34,560. What is 43,560? Question rationale. There are 43,560 square feet in an acre. Mechanics liens are based on the California Civil Code, Federal Mechanics lien law, English common law, the Business and Professions Code. What is the California Civil Code? In California, mechanics lien law is statutory law contained in the California Civil Code. The deed restrictions on a subdivision said that the lots must contain a minimum of 15,000 square feet. The zoning restrictions said that the lots must contain a minimum of 10,000 square feet. Which would prevail? Zoning restrictions. The one recorded last, the one recorded first. Deed restrictions. What is the deed restriction? In situations where you have both a deed restriction, restrictive covenant, and zoning restrictions, the more restrictive or limiting of the two applies. The best way to think of this situation is which number meets both restrictions? If you went with zoning restrictions and built your lots to 10,000 square feet, you would not meet the subdivision's minimum of 15,000 square feet per lot. But if you built your lots to 15,000 square feet, you would also satisfy the 10,000 square feet per lot minimum of the zoning restrictions. An individual sold her house and moved into a cooperative apartment. Under the cooperative form of ownership, the individual will become a shareholder in the corporation, have to take out a new mortgage loan on her unit, receive a fixed term lease for her unit, not lose her apartment if she pays her share of the expenses. What is become a shareholder in the corporation? Cooperative ownership is an apartment ownership similar to a condominium. In a cooperative ownership, the buyer receives shares of stock in the building corporation and a lease, or assignment of the seller's lease, of the apartment being sold. The seizure of property prior to a judgment is known as an attachment. Serving the judgment. A seizure execution. Excessive force. What is an attachment? An attachment is a process by which a defendant's real or personal property is seized prior to a judgment being rendered in a lawsuit, although attachments can be issued after final judgment as well. Which of the following notices could be important to the filing of a mechanics lien? Notice of cessation, notice of completion, notice of non-responsibility, notice of cessation and notice of completion, notice of non-responsibility. What is notice of non-responsibility, notice of cessation and notice of completion? Notices for mechanics liens are completion, cessation and non-responsibility. Pedro sold Happland to Josh. At the time, Happland had an appurtenant easement across Pleasantville, which was owned by Jethro. When Josh tried to use the easement, Jethro protested. Which of the following is correct? The owner of the easement can give it to anyone. Jethro owns the servient tenement and this consent must be obtained for Josh to use the easement. Pedro owns the dominant tenement and the easement upon it. An appurtenant easement always passes when the property is sold. What is an appurtenant easement? Always passes when the property is sold. Appurtenances are said to run with the land and they require no separate conveyance. Appurtenances include easements, stock in a mutual water company, covenants, and minerals. They are considered real property. Which of the following is not an example of police power? Health and safety, rent control, zoning, declaration of restrictions. What is declaration of restrictions? Be careful of the word not in the question. Declaration of restrictions is a statement made by a developer of a new subdivision which sets out the restrictions of general application throughout the new development. Police power is the power and authority of the government to enforce the laws of the government to protect the health, safety, morals and the general welfare of the public. Examples of police power would include zoning and rent control. 2. Pre-patent contracts. What is it called when one person is substituted for another in a real estate contract? Redaction, novation, subordination, hypothecation. What is novation? The most general definition of novation is the substitution of a new obligation for an old one. It also means substitution of new parties to an existing obligation, as when the parties to an agreement accept a new debtor in place of an old one. For example, in the assumption of a loan, the lender may release a seller and substitute the buyer as the party primarily liable for the mortgage debt. A listing agreement is essentially a/an purchase contract, a unilateral contract, employment contract, option to sell. What is employment contract? A listing is a bilateral employment contract between principal and broker whereby the broker is employed by the principal to find a buyer and accept a deposit. Usually a broker has a right to a commission only on the basis of negotiations which he completes during the term of the listing agreement, unless he brings a court suit against his principal. The listing agreement has a liquidated damages clause. The listing involves the exchange of properties. A protection period clause is included in the agreement. What is a protection period clause? Is included in the agreement. A protection period clause, safety clause, in a listing will allow a broker to collect a commission for a specified period of time after the term of the listing has expired. It is a designated period of time to close deals with prospects that the licensee has been working with during the term of the listing. This is not a time to find a new prospect. They must put the name of the prospects in writing at the end of the listing period in order to earn a commission during the protection period clause. Broker Kim took a 90-day exclusive agency listing to sell Joe's property. After 30 days, Kim still hadn't sold the property, so Joe sent her a certified mail letter canceling the listing. 1 week later, Joe listed the property with several brokers using open listings. 2 weeks later, one of the brokers who had an open listing on the property completed a sale to new owners. In this situation, Joe most likely had a right to relist property and cancel Kim's listing, and his notice of cancellation would accomplish this without possible liability to Joe. Owes commission to the selling broker only. Did not have the right to give open listings to other brokers. Is liable for payment of commission to Kim as well as to the selling broker. What is liable for payment of commission to Kim as well as to the selling broker? An exclusive agency listing is a bilateral employment contract that guarantees a commission to the exclusive agent if any licensee procures a buyer, although the owner can procure a buyer without paying a commission. Joe can't unilaterally decide to cancel an employment contract that requires mutual consent. So even though Joe sent a certified letter, if broker Kim didn't agree to cancel the contract, the listing is still enforceable and Joe could be liable for both commissions. This would apply if the question had stated an exclusive right to sell listing as well. 2. Compub-Gran contracts. A real estate agent presents a full price cash offer, with no contingencies, during the initial listing period. The seller refuses to sign the contract, because they don't like the buyers. Which situation is correct? The listing contract would be automatically terminated. The listing agency is due a commission, correct? No commission can be due unless there is a closing incorrect. The buyer could sue for specific performance. What is the listing agency is due a commission? Question rationale. Although sellers are not obligated to accept any offer on their home, the contract with the broker most likely will obligate them to pay a commission, as the broker has done what they were hired to do. A buyer submits an offer to purchase a home and the seller, wishing to keep the dining room chandelier, adds to the contract the words dining room chandelier not included, before signing and returning it to the buyer. Is the contract binding? No, the seller rejected the buyer's offer. No, to be binding, the seller's counteroffer must now be accepted by the buyer without further change. Incorrect. Yes, the seller only made an insignificant change. No, the seller rejected the buyer's offer, and to be binding, the seller's counteroffer must now be accepted by the buyer without further change. Correct. What is no? The seller rejected the buyer's offer, and to be binding, the seller's counteroffer must now be accepted by the buyer without further change. Question rationale to create a contract. The acceptance of an offer must not vary the terms of the offer or add new terms. A counteroffer is essentially a rejection, a change, and a new offer. A home buyer wishes to make an offer on her home but has little money. On the contract, he puts down $0 as earnest money. Which is correct? Even if the seller signs, the buyer is not bound. The minimum earnest money is 1% of the offer. The contract is not valid without earnest money. Incorrect. The contract, when signed by the seller, is fully enforceable. Correct. What is the contract, when signed by the seller, is fully enforceable? Question rationale. There is no requirement for earnest money, although, in practice, it is a good idea. An educated seller or listing agent will probably request it, but it does not affect the validity of the contract. Prospective buyer B is not quite ready to purchase yet, so he rents a home with the option to purchase it after 2 years. This option to purchase is an example of a unilateral contract. Correct. Promise and exchange contract. Bilateral contract. Incorrect. Mutual contract. What is unilateral contract? Question rationale. Options are unilateral, or one-way, contracts. The seller is obligated to sell, but the buyer is not obligated to purchase. When a property is listed, it is a solicitation of offers to buy. Correct. An offer to sell. Incorrect. An option. A contract. What is a solicitation of offers to buy? Question rationale. A real estate listing is not considered a property owner's offer to sell. A buyer doesn't create a contract by accepting the seller's listing. Rather, a buyer makes a written offer to purchase and the seller may accept or reject the offer. Or, the seller may agree to enter into an option contract, allowing the potential buyer time to decide whether to buy or not. A legal remedy which would compel a vendor to execute a deed pursuant to a valid land installment contract is known as specific performance. Correct. Writ of execution. Incorrect. Execution of sales. The equity of redemption. What is specific performance? Question rationale. Specific performance is a remedy available to the buyer, e. the vendee in a land contract, that would force a vendor, e. the seller, to simply execute the deed and specifically perform the promises that were given in the land installment contract. Old Man Jones wants to settle his affairs prior to his death by selling his land and giving the money to his children. Broker Bob lists the property and markets it. After 6 months, an offer from crazy old Widow Smith, who lives in the next county, is received in the mail. Jones immediately signs the contract without change, and Broker Bob drives to the next county to deliver a copy to the widow in person. What might prevent this from being a binding contract? Either Widow Smith is incompetent or Widow Smith's death before Bob can relate Jones' acceptance. Correct. Widow Smith's death before Broker Bob can relate Jones' acceptance. Nothing. Widow Smith is, in fact, incompetent. Incorrect. What is either Widow Smith is incompetent or Widow Smith's death before Bob can relate Jones' acceptance? Question rationale. Death or incapacity of one of the parties often makes it impossible to form a contract. If the landlord and the area real estate manager of a national retailer both execute a lease, and the corporation fails to occupy the premises, what might prevent the landlord from enforcing the terms of contract? The broker did not have a written listing. The economy declined and the retailer was closing other stores. No corporate resolution granting signing authority to the real estate manager was approved. Correct. The real estate manager had authority to make the deal. What is no corporate resolution granting signing authority to the real estate manager was approved? Question rationale. A broker should always make sure, when the principals in a transaction are not personally executing binding documentation, that their representatives have full authority to commit the principal to the terms of the obligation. Neither favorable nor unfavorable general economic conditions are a required element of contracts, nor is the existence of a brokerage listing agreement. The landlord might, however, be able to claim damages from the retailer if the retailer's real estate manager said he had authority to sign and in doing so, exceeded the scope of his agency. Once a contract has been rescinded, and each party returns to the other any consideration that has been tendered, what has occurred? Cancellation. Incorrect. Restoration. Replacement. Restitution. Correct. What is restitution? Question. Rationale. Restitution is rescission where the contract is undone, all obligations terminated, and all consideration returned. Cancellation is termination without undoing any of the acts that have been performed under the contract. In real property terminology, replacement may refer to rebuilding improvements to the same functional and economic value as before. Restoration may refer to reconstructing improvements to the same physical status and appearance as before. The term amortization refers to a balloon payment at the end of a loan. Incorrect. Interest-only payments over the life of a loan. A repayment of a loan by principal payment only. Payment of a debt in regular periodic installments of principal and interest. Correct. What is payment of a debt in regular periodic installments of principal and interest? Question. Rationale. Amortization refers to payment of debt in regular periodic installments. An interest-only payment refers to a straight-term or straight-line mortgage and often includes a balloon payment at the end of the loan. Typically, a builder would have what type of mortgage on his development? A wraparound with a partial release clause. Incorrect. A blanket. Correct. An interest-only with annual payments due. A conventional fully amortized. What is a blanket? Question. Rationale. A wraparound mortgage is a second mortgage written to cover the first and second mortgages on one property. An interest-only mortgage is usually a very short-term loan with the payments going only to the interest on the loan. A blank mortgage covers more than one property, with the development and its parcels released as they are sold. A fully amortized conventional loan would cover one parcel only, with part of the payment going toward interest and part going toward principal. The balance is due at the end of the loan period. The taking of another person's rights and obligations in a pre-existing contract is known as ostensible liability. Assignment. Assumption. Correct. Novation. What is assumption? Question. Rationale. Assumption involves the taking or receiving of another person's rights. Assignment is the giving of a person's rights and interests under a contract to someone else. While assignment is without release of liability, novation does release a withdrawing party from liability under a contract. 2. Prepage and transfer of property. The main purpose of a deed is to provide evidence of the terms of a real property transaction, identify the parties involved in real property transfer, provide a written instrument that can be recorded evidence of the change in title or transfer of an interest in real property. What is evidence of the change in title or transfer of an interest in real property? Deeds provide evidence of the transfer of title of real property from a grantor to a grantee. Deed requires the grantor must be legally competent. It must be delivered and accepted and contain a granting or action clause. A deed does not need to be acknowledged to be valid. What is the main duty of the county assessor? Assign parcel numbers to new developments for the purposes of assessing and recording property taxes. Determine the amount of tax to be paid by property owners. Determine the percentage of assessed value that property owners will pay in taxes. Determine the tax rate that will be assessed by property owners. What is determine the amount of tax to be paid by property owners? The assessor is a local government official who estimates the value of real property within a city, town, or village's boundaries. This value is converted into an assessment, which is one component in the computation of real property tax bills. For homestead to be effective, when must a homeowner assert those rights? Before any court judgments are rendered. Before any lawsuits are filed by creditors. Before any court judgments are recorded. Before any bankruptcy proceedings begin. What is before any court judgments are recorded? In bankruptcy proceedings, a judgment is first rendered before it is recorded and made final. Homestead rights may be asserted up to that last moment. If a person buys property in a California land project and then changes his mind, he can obtain a refund of his money without a specific reason. Within how long? 7 days, 14 days, 3 days, 5 days. What is 14 days? A buyer in a land project has 14 days to rescind his purchase. Which of the following closing costs would be classified as a recurring cost? Impound account items, escrow fees, recording fees, title insurance premiums. What is impound account items? Impounds are created for recurring costs such as taxes and insurance. Alyssa died intestate, leaving a large estate and no heirs. What is the most likely disposition of her property? It will be sold, all taxes and debts settled, with the remainder going into trust for possible heirs. It will be held in escrow until a will is located. It will be sold for any back taxes, with the remainder going to the state. It will escheat to the state if no claims are made by possible heirs. What is it will escheat to the state if no claims are made by possible heirs? Escheat means to revert, which is what will happen if no heirs come forward and establish a valid claim within the 5-year period. A grant deed is deemed to be executed when it is signed by the grantor, delivered to the grantee, delivered to escrow, recorded. What is signed by the grantor? Grant deeds include a warranty that the seller, grantor, has the unencumbered right to transfer ownership to the buyer, grantee. It is not necessary to record a grant deed for it to effectively transfer title. In California, a deed is not considered to be effective until it has been delivered and accepted, but it is considered officially executed when signed by the grantor. Which of the following may appear on a closing statement as a credit to the buyer? The balance of an assumed loan, property taxes after the closing date of March 31st until June 30th, commission paid to the broker, property taxes after November 15th to the date of closing. What is the balance of an assumed loan? A loan assumption is a transaction in which a person, the assumptor, obtains an ownership interest in real property from another person and accepts responsibility for the terms, payments and obligations of that other person's mortgage loan. It is money the buyer doesn't need to bring to the table at closing, so it's a credit to the buyer on the closing statement, even though it's a debit to the buyer's personal accounts. 2. Prepayment laws of agency. Which of these is a duty of licensees under both commission rules and fiduciary responsibility? To disclose all facts that might affect the sale. To keep all information provided by both buyers and sellers confidential. To disclose material information that might affect the price and/or sale of the property, even if the buyer does not ask for it. To keep all information provided by sellers confidential. What is to disclose material information that might affect the price and/or sale of the property, even if the buyer does not ask for it? Confidential information must be respected, but not all information qualifies as confidential. Moreover, in certain circumstances, confidential information may be disclosed, with permission, on a need-to-know basis. However, material information such as a faulty foundation or plans calling for a new shopping center to be constructed immediately behind the property must be disclosed even if potential buyers never raise the issue. The fiduciary obligation to protect a client's confidential information continues for 3 years after escrow closes after the term of the listing agreement only while escrow is opened for the term of the listing agreement. What is after the term of the listing agreement? Much like a doctor or a lawyer, a licensee has a duty to protect a client's confidential information that continues even after a listing has expired. Which is an example of ostensible agency. A broker is able to sell all of an owner's properties and is granted power of attorney for all the owner's affairs. The principle allows the licensee to act as the listing broker in front of a prospective buyer. A selling broker acting as a subagent of a listing broker. A broker was able to sell only one of an owner's properties. What is the principle allows a licensee to act as the listing broker in front of a prospective buyer? Ostensible agency is similar to implied agency in that the relationship is created by the actions of the parties, rather than by written contract. Ostensible agency occurs when a third party would reasonably believe an agency agreement exists between a principal and an agent, even if no such agreement was ever made. Even in those states that recognize ostensible and implied agency relationships as binding, a written agency agreement should be obtained as soon as possible to clarify the understandings of all parties and protect interests. 2. Compukran laws of agency. An agency relationship can be terminated legally without recourse under which of the following circumstances? When the listing salesperson dies. When the salesperson becomes mentally incompetent. When the listing broker dies. Correct. When the buyer dies. Incorrect. What is when the listing broker dies? Question. Rationale. The listing broker is the agent of record in a listing. A listing is an employment agreement, therefore, when an employee dies, the agreement is void. This is not the salesperson's listing. The listing belongs to the broker of record in every transaction, not to the agent. Under common law, an agent's fiduciary obligations to her client include concern, discretion, accountability and loyalty. Notification, obedience, loyalty and confidentiality. Care, obedience, loyalty, accountability and notice. Correct. Communication, obedience, loyalty, agency and notice. Incorrect. What is care, obedience, loyalty, accountability and notice? Question. Rationale. These duties are often remembered by the acronym of : a licensed real estate salesperson is permitted by law to represent himself as a broker, one or more brokers, any interested party. Incorrect. His sponsoring broker only. Correct. What is his sponsoring broker only? Question. Rationale. A licensed real estate salesperson works for his broker only, and acts on behalf of his broker as a subagent to the buyer or seller. The salesperson's responsibility and authority come only from his broker. 2. Pre-pagent practice and disclosures. In assessing the profitability of a real estate office, the broker must consider desk cost. Which answer best describes how to calculate desk cost? Divide the total cost of rent, utilities, and advertising by the number of salespersons. Calculate the cost of all the desks. Divide the total operating expenses of the office, including salaries, rent, insurance, etc., by the number of salespersons. Calculate the gross profit for the office, less the expenses, divide by the number of salespersons. What is divide the total operating expenses of the office, including salaries, rent, insurance, etc., by the number of salespersons? Desk cost are the total operating expenses of a broker's office divided by the total number of salespersons in that same office. Jason owns a property in Bel Air and enters into an exclusive right to sell contract with Beverly, a licensed broker. As part of the agreement, Beverly agrees to advertise the home in a special properties catalog at a cost of $250, which Jason agrees to pay. How must Beverly handle Jason's check? Send it immediately to the publication where the ad will appear. Place it into her business account until it comes time to pay for the ad. Place it in her trust account and draw against it only to pay actual advertising expenses. As an incidental sum, it requires no special treatment, but must be accounted for. What is place it in her trust account and draw against it only to pay actual advertising expenses? Any money given by a client to a salesperson or broker must be deposited into the broker's trust account. All of the following are lawful except an agent of the buyer talking to the seller not having a transfer disclosure statement in a foreclosure sale, a broker accepting a referral fee from a title company, a broker escrowing a transaction. What is a broker accepting a referral fee from a title company? Brokers are not allowed to accept referral fees, kickbacks, from a title company, while all the other options are allowed. Note, this question asks all of the following are lawful except, which means it's looking for a false answer, and it's false that brokers can accept referral fees from title companies. Broker Torres had an open listing on a property. He showed the property to a buyer who purchased it. Since this was an open listing agreement, what must Broker Torres do to be assured he will receive his commission from the seller? Instructions should be given to the escrow office to pay the commission directly to the broker. Since the listing was open, the seller should be instructed to pay the commission directly to the broker. The payment of commission would be handled the same as any other listing. File a suit against the seller to demand the commission be paid. What is the payment of commission? Would be handled the same as any other listing. Payment of commissions with an open listing are handled the same as any other listing. The details must be worked out in the listing agreement itself. What is RESPA? A standard for access and accommodation for persons with disabilities. A federal anti-discrimination statute. A standard for closing procedures. A low-income housing program. What is a standard for closing procedures? The intent of RESPA, the Federal Real Estate Settlement Procedures Act, is to make borrowers more aware of costs and charges. Allison has just qualified for her salesperson's license. How much time does she have to file her application to practice? 1 year from the date she was notified she passed the exam. 1 year from the date she passed the exam. 2 years from the date she was notified she had passed the exam. 2 years from the date she passed the exam. What is 1 year from the date she passed the exam? Although most people who pass the exam are anxious to get their license and begin practicing real estate, the rules do allow up to a year to make the application. If a seller wanted to relieve himself of the primary liability for payment of a trust deed and note, he must find a buyer who is willing to sign a release agreement, take title subject to the trust deed and note, execute a subordination agreement, assume the trust deed and note liability. What is assume the trust deed and note liability? When a buyer assumes a mortgage from the seller, they are relieving them of any future obligations. When financing a home with a long-term loan, if equal monthly payments are made, the amount of each payment applied to the outstanding principal balance will decrease at a constant rate. Decrease while the interest payment increases. Increase while the interest payment decreases. Increase by a constant amount throughout the life of the loan. What is increase while the interest payment decreases? This is a loan having equal payments, usually monthly, where interest is figured on the declining principal balance. As the principal decreases, interest also decreases, applying more of each payment to principal. An acceleration clause is inserted into a note that is otherwise negotiable. Adding this clause does not limit the negotiability of the note. Makes the note non-negotiable. Has no effect on negotiability, but also is of no benefit to the holder of the note. Is required to be negotiable. What is does not limit the negotiability of the note. An acceleration clause in a loan can cause the entire unpaid balance to be due immediately upon default of the loan. Adding this clause does not generally limit the negotiability of the note. A commercial bank agreed to lend Davis $180,000 for 1 year term. Davis agreed to maintain a savings account with the bank in the amount of $18,000 during the term of the loan. This provision is known as compensating balance, a security deposit, mortgage insurance, risk management. What is compensating balance? Compensating balance is a minimum balance that must be maintained in an account. The compensating balance is often used to offset a portion of the cost that a bank faces when extending a loan or credit to an individual or business, and is usually calculated as a percentage of the loan outstanding. The account where the funds are held are typically non-interest bearing, and the bank is free to use the money in other investment opportunities. It would be to the advantage of lending institutions to waive prepayment penalties when which of the following is occurring? The Federal Reserve sets standards for banks to follow. Funds are in short supply and the demand for loans is high. Funds are easily available and the demand for loans is low. The Federal Reserve drastically raises the discount rate and reserve requirement. What is funds are in short supply and the demand for loans is high? It would be to the advantage of lending institutions to waive prepayment penalties when funds are in short supply and the demand for loans is high. This incentivizes early mortgage payoff, which creates an inflow of funds that can be loaned back out. 2. Compucram transfer of property. The successive conveyances affecting a particular parcel of land, arranged consecutively from the original source of ownership to the present-day owner, is called certificate of title. Abstract of title. Chain of title. Correct. Estoppel certificate. What is chain of title? Question rationale from the original source to the present owner. A certificate of title, also known as an opinion letter, is a statement issued by an attorney as to who presently owns the property. An estoppel certificate is a document used by a lender to lock in the principal amount that is still owed by a borrower to a seller each year. An abstract of title is a compilation of all the deeds, liens, mortgages, and any or all other documents recorded on behalf of each and every owner of real property, put in a history book form. A written instrument transferring the grantor's ownership of or interest in real property is known as deed. Correct. Title. Easement. Mortgage. What is a deed? Question rationale. An easement is the right acquired by one person to use the land of another for a specific purpose. Title refers to the actual ownership of property. A deed is not title. A buyer contracts to purchase a $75,000 home and puts up an earnest money deposit of $1,500. The commission is 5%, paid by seller. The buyer gets a $260 credit for real property taxes paid in arrears. A buyer obtains an 80% conventional loan at 12% interest with 3 points. What amount should the buyer bring to closing? $19,913. $15,040 correct. $16,540. $15,800. What is $15,040? Question rationale. An 80% loan of $75,000 is a loan for $60,000. 3 points of $60,000, or 3%, equals $1,800. He gets a credit for $260 for taxes and a credit for $1,500 for his earnest money deposit, reducing the amount to bring to closing to $15,040, down payment plus closing costs. The seller, not the buyer, paid the real estate commission. What does a title company do? Ensure clear title to real property. Correct. Hold escrow. Transfer title from grantor to grantee. Incorrect. Convey equitable title from vendor to vendee. What is ensure clear title to real property? Question rationale. The title company ensures clear title to real property by examining the title and making sure the chain of title is correct. In the closing statement required by RESPA, the sales commission is shown as a credit to the seller, debit to the buyer, credit to the buyer, debit to the seller. Correct. What is debit to the seller? Question rationale. The sales commission is paid by the seller at closing and thus reduces his net from the sale of the property, so this is a debit to him. A quitclaim deed conveys only the interest of the grantee, the grantor. Correct. The vendee, property. Incorrect. What is the grantor? Question rationale. The grantor and the grantee are the parties to a deed. A quitclaim deed transfers the interest of the grantor only. A grantee does not sign a deed. A vendee is the buyer in a land contract. What kind of title does the vendee have? Equitable title. Correct. Bare legal title. Incorrect. Naked title. Quiet title. What is equitable title? Question rationale. The vendee, when entering into a land contract, does not get legal title until the terms of the land contract have been met. Before that time, the buyer has equitable title. 2. Pre-pagent valuation and market analysis. Looking at shopping centers in the appraisal process, the social fiber of the community and distances from schools is called market data approach. Social analysis, site analysis, neighborhood analysis. What is neighborhood analysis? This involves more than just driving around. It is a formal process of identifying, measuring and analyzing the influences that help determine a neighborhood's vitality and desirability. Which of the following approaches to value would be most concerned with the present worth of the future potential benefits of the property? Summation. Market data. Income cost. What is income? The income approach emphasizes the present worth of future benefits. Arthur is an appraiser appraising a single-family home. Author considers which of these in determining the value of a property? Racial demographics. Pending property sales. All properties located within a 10-mile radius. Date sold of any comparable properties. What is date sold of any comparable? When assessing a single-family home, Arthur will want to know the closing price of similar homes in the area, but only for about a 6 to 9 month period, so the date a comparable was sold matters. A home appraisal is an unbiased estimate of the true, or fair market, value of a home's worth. Lenders order appraisals during the mortgage loan process to get an objective assessment of the home's market value and ensure that the amount of money the borrower is requesting is appropriate. An appraiser who uses improper methods to appraise a property for a government-backed loan may be guilty of violating real estate licensing law, a misdemeanor, a felony, violating appraisal ethics. What is a felony? The appraiser must utilize proper and accepted methodology with respect to property backed by a government loan in conducting his appraisal, or he will be guilty of a felony. The most comprehensive and complete appraisal report is the oral form report, narrative report, letter form report, certificate report. What is narrative report? Narrative report is the most comprehensive of the 3 types: letter form, short form, narrative, that includes all the information obtained by the appraiser as well as the methodology behind the calculations and value conclusion. But as comprehensive as it may be, it does not contain the buyer's financial condition, because how you pay for the property is not relevant to the value of the property itself. A piece of lumber 6 by 12 by 2 contains exactly 1/2 of a board foot. Contains exactly 1 board foot. Contains exactly 3 board feet. Contains exactly 2 board feet. What is contains exactly 1 board foot? A board foot is a volume measurement for lumber equal to 144 cubic inches. Note, to find the cubic measurement of any object you multiply each side. In this measurement you would multiply 6 by 12 by 2 equals 144 inches. A board foot is any piece of lumber that's cubic measurements total 144 inches. Palisades construction is completing a new home and must backfill. What is backfill? Dirt from an excavation that must be hauled off a property. None of the other options are correct. Dirt, usually left over from excavation, that is used to fill in space around a foundation or other structure. Dirt or topsoil that is used to berm and create landscaping interest. What is dirt, usually left over from excavation, that is used to fill in space around a foundation or other structure? Backfill has no negative connotations. It's simply that excavations for foundations and such must be wider than the structural elements to permit space to work. Once complete and cured, this space must be filled in again for stability and drainage. In the capitalization method of appraising, the most difficult step is to establish the effective gross income, establish the net income, select a capitalization rate. Establish the gross income, would select a capitalization rate. The hardest part of the capitalization approach is determining the capitalization rate. 2. Common practice of real estate and mandated disclosures. When showing a listing, a sales agent is asked about the condition of the basement. Without having seen the basement, the agent states that, to the best of his knowledge, the basement is dry and free of dampness. In fact, the basement leaks steadily whenever there is rain. The agent most likely has committed fraud. Misrepresentation correct. No error. This is protecting the homeowner's interest. Intentional misrepresentation incorrect. What is misrepresentation? Question rationale. The agent has misrepresented the condition of the property and, therefore, is negligent. Fraud is an intentional misrepresentation. While the sales agent did not intentionally misrepresent the condition of the basement, he should have exercised reasonable care and viewed the basement before making any statements concerning its condition. A seller completes a property disclosure form and states that there are no conditions in the property that are in need of repair. However, the listing sales agent recognizes the early signs of termite infestation. The sales agent should not tell the buyer and rely upon the seller's statements in the property disclosure form. Disclose the condition to the buyer, as this is a patent defect. Correct. Disclose this condition to the buyer, as this is a latent defect. Tell the seller to amend the property disclosure statement. Incorrect. What is disclose the condition to the buyer, as this is a patent defect? Question rationale. The sales agent should disclose this condition to the buyer, as this is a patent defect and would be discovered by a reasonably thorough inspection. A latent defect is a fault in the property that could not have been discovered by a reasonably thorough inspection before the sale. There is no duty to amend a property disclosure form once it has been given, and the agent should not rely upon the seller's representations, or in this case, misrepresentations, as a shield of liability for non-disclosure. Where would one file a complaint based on the Rumford Act? OEO? NAACP? ECA? Department of Fair Employment and Housing. Correct. What is the Department of Fair Employment and Housing? Question rationale. A complaint based on the Rumford Act can be filed with the Department of Fair Employment and Housing. A real estate licensee needs to have little understanding of law, because competent attorneys are available. A broad understanding of law and how it affects real estate. Correct. An in-depth understanding of constitutional law. Legal experience as a practicing lawyer. What is a broad understanding of law and how it affects real estate? Question rationale. Competent attorneys are not always available. An agent does not need to have experience as a practicing attorney, though an in-depth understanding of constitutional law might help. It is not a necessity. A real estate agent should have a broad understanding of the law and how it affects real estate, and should have enough experience to recognize a potential legal problem, and then refer that problem to a competent attorney. The agency of the federal government which administers fair housing law is ARI. Narrow. HUD correct. VA. What is HUD? Question rationale. The Office of Equal Housing Opportunity is a division of HUD. Housing and Urban Development. This department is in charge of enforcing and administering fair housing laws.